Welcome, everyone, and thank you for being with us today. Today's webinar is organized by 4IP Council. My name is Claudia Tapia. I'm the president of 4IP Council, and I will be your host today. As you may know, 4IP Council is a not-for-profit research organization. We focus on the relationship between intellectual property and innovation. We produce empirical research on relevant topics. This work is done in collaboration with a variety of academics, experts, IP organizations, and other stakeholders. On our website, you will find many free material. This includes papers, summaries, studies, and guides. We also share webinar recordings, like the one today. I strongly encourage you visiting our cellular standards section, IoT and cellular standards, and listening to our podcast, IP Stories. We also have a dedicated area for SMEs. A few months ago, we launched a new section on AI and intellectual property rights. It includes guides, videos, papers, and interviews. This way, you can be updated on the pressing questions arising around intellectual property rights. Without further delay, it is my pleasure to introduce our speakers for today's webinar, Professor Francesca Ferrari, Léon Dijkman, and Dean Kristen Osenga. Francesca is an associate professor at the Economics Department of Insuria University in the field of civil procedural law. Since 2020 and 2023, she has been qualified to hold the position of full professor in civil procedural law and in comparative law. Leon is attorney at law with Hohenbroek Monsignor in Amsterdam and assistant professor of law at the Institute for Information Law at the University of Amsterdam. Kristen is Julie and John Nowak Faculty Research Scholar and Professor of Law, and Associate Dean for Academic Affairs at University of Richmond School of Law. A final remark for the audience. Please do not hesitate to use the Q&A tool to submit your live questions. You can find it in the lower part of the screen. You can raise your questions anytime during the webinar, and the questions will be addressed following the presentations. With that, I'd like to give the floor to you, Francesca.
Thank you very much, Claudia. And first of all, thank you very much for the invitation to this webinar and for the interest in my paper. I would like to thank also Leon and Kristen to be here to discuss it. My paper is focused on the remedial architecture of EU intellectual property enforcement, and in particular on the place of proportionality within that architecture. The starting point is a practical and institutional observation. Even when substantive intellectual property rules have been progressively harmonized across the Union, enforcement has historically remained an area in which national divergence could decisively shape outcomes. In a market defined by cross-border trade and obviously in which often and increasingly occur cross-border infringements, the effectiveness of EU intellectual property law depends on the credibility, the predictability, and coherence of enforcement. And this is why we have to go back to Directive 2004/48, well known as Enforcement Directive or IPRED. This directive has to be understood not as a technical procedural tool, but much more as a cornerstone of the US innovation and competitiveness framework. It reflects a regulatory premise that intellectual property rights function as instruments supporting innovation-driven growth, and that credible remedies are necessary to ensure that creators and innovators can secure adequate returns and investments. The core question is not whether enforcement should be there and whether it should be strong or not. The question is how enforcement should be structured so that it remains effective and dissuasive while also remaining fair, constitutionally grounded, and compatible with internal market. And in my view, that is where the proportionality criterion becomes decisive. As we will see in the next, I hope no more than 20 minutes, a recurrent theme in contemporary debate is the suggestion that EU should move to the post-eBay American approach to enforcement, or better, to injunctions, a model in which injunctive relief is not structurally default, but must be justified case by case through an equitable balancing framework. The argument I'm developing through a comparison with the US system is that this move would imply an institutional mistake. Because it would treat proportionality in the EU as functionally equivalent to the US equity, forgetting that proportionality and equity operate within two completely different legal architectures and have their roots in two completely different remedial cultures. But what is IPRED? IPRED, as we all know, was adopted in 2004. Its legal basis is the Article 114 of the Treaty on the Functioning of the EU, which empowers the Union to approximate national laws to ensure the establishment and functioning of the internal market. And why this is relevant? Because the directive was not designed as a civil procedure code, but it was designed to raise the enforcement floor to a reliable and credible minimum across member states, thereby reducing all the enforcement disparities that distorted competition and generated legal uncertainty for cross-border trade. This internal market rationale is reinforced by the directive's alignment with international obligations under TRIPS and by its recital, all emphasizing innovation, investment, competitiveness. It's clear without predictable enforcement, the economic value of IP rights becomes uncertain, incentives weaken, and the internal market fragments in practice, even if it is integrated in law. IPRED, from this point of view, embodies a deliberate compromise. It harmonizes key remedial tools, but preserve the member states' autonomy regarding institutional design and procedural details. In a certain way, its minimum harmonization is oriented toward systemic convergence over time through EU case law, through national adaptation, and more recently, also through supranational patent adjudication. To understand why the directive architecture is relevant, we should go back to how the enforcement looked like before IPRED. At a macro level, what we can say is that at that time, the divergences among the member states were really relevant. And these divergences distorted the competition and in a certain way were in contrast with the assumption for which credible enforcement is relevant because it reduces transaction costs and it enhances legal certainty, and especially obviously in cross-border commercial activities. As we can see from the slide, the divergences existed across all the enforcement spectrum, and we had divergences in the evidence preservation and access to information, in the provisional measure, corrective measures, and final injunctions, damages, costs. The heterogeneity generated obviously a lot of consequences. First of all, forum shopping. But second, those divergences undermine the credibility of EU IP law within the internal market. And in a certain way, IPRED was adopted precisely to address this problem and to establish, as I said before, a minimum EU-wide enforcement floor. Article 3 and Recital 17 of the IPRED are the normative heart of the directive's remedial architecture. And as we can see from Article 3, the remedies must be effective, proportionate, and dissuasive, but they must also be fair and equitable, not unnecessarily complicated or costly, and applied so as to avoid barriers to legitimate trade while providing safeguards against abuse. In my view, there's a point that is methodological. Proportionality in this context is not a free-floating balancing slogan. It is a legal constraint. It shapes the way remedies are designed and implemented. So it does not negate liability once infringement is found, but it rules the remedy so that enforcement remains constitutionally and economically legitimate. At EU level, the Court of Justice has progressively infused proportionality into enforcement jurisprudence. Now I'm talking mainly about intermediary jurisprudence. But the point is that the Court of Justice emphasized that intellectual property are fundamental rights under Article 17.2 of the Charter, but they are not absolute. So they must be protected, but enforcement must reflect a fair balance between IP protection and other charter protected rights, including freedom of expression, information, freedom to conduct a business. As I said before, this becomes especially visible in the case law on injunctions against intermediaries, in the context of which the Court of Justice specified that injunctions must remain available and effective as routine elements of enforcement, but they must be disciplined through structured proportionality, preventing general monitoring obligations and undue impact on unlawful commerce and third-party freedoms. This logic is exemplified in, I deem, all the cases I mentioned in the slide. And it has been exemplified also in more recent jurisprudence concerning platform and data-related enforcement. The key analytical consequence is that EU proportionality is not designed to transform injunctions into exceptional remedies granted only after broad discretion. It functions to prevent abusive, excessively harmful, or constitutionally overbroad enforcement, while preserving injunctions as a core enforcement tool. Provisional measures are central to effective enforcement, and this is I think, true in all the field, but particularly in fast-moving markets and with respect to rights like intellectual property one, where delay can render final relief meaningless. From this point of view, Article 9 IPRED requires that courts be able to order prompt and effective provisional measures to prevent imminent and ongoing enforcement. But it is also true that within the IPRED, provisional measures are considered also as possibly as a possible mistake. So they can create a risk of error. So interim relief may later prove unwarranted. EU practice has therefore developed a sophisticated pattern of risk allocation and ex post safeguards. What does it mean? It means that proportionality here operates in two directions. It requires effectiveness, but it also requires mechanisms to mitigate the costs of wrongful interim relief. In other words, in preliminary injunctions, proportionality does not mean reluctance to issue or reluctance or under enforcement, but it means designing interim relief that remains operationally effective. It has to be mentioned also that damages under IPRED are compensatory. And this is particularly relevant because damages are conceived to restore the right holder to the position they would have in absent infringement, including through methodologies as actual prejudice or hypothetical royalties. But the architecture excludes punitive or exemplary damages. And this feature has systemic consequences in my view, because if damages are compensatory, they cannot fully substitute the deterrent and exclusion function of injunctions. So the enforcement system, without having punitive damages, cannot trade injunctions for damages. A regime with reduced injunction but without enhanced damages risks incentivizing infringement as a calculated cost of business. This is exactly why proportionality in the EU system must be understood as a targeted safeguard, not as an open-ended balance device. If proportionality were used to systematically deny injunctions, the compensatory damage model would not pick up the slack. And now let's go to the other side of the Atlantic. In the other side of the Atlantic, before eBay, US courts routinely granted injunctions in patent and copyright cases, reflecting a property rule conception of IP. Critics argued that this facilitated strategic behavior and created excessive settlement pressure, especially in complex technology markets. In 2006, as we all know, the Supreme Court held that a patent holder seeking an injunction, a permanent injunction, must satisfy a four-factor test applied in equity. The test requires a plaintiff to establish irreparable harm, inadequacy of legal remedies, so to demonstrate the monetary damages are insufficient, that the balance of hardship warrants equitable relief, and that the public interest would not be disturbed by an injunction. Doctrinally, this matters because it changes the structure of remedial reasoning. The first two factors we were talking about shift attention to whether exclusion is genuinely necessary. The other two factors explicitly invite courts to evaluate consequences beyond the bilateral dispute. After eBay, I think Kristen will say something more about it, but injunctions were denied in a significant number of cases, particularly where the patentee operated primarily as a licensing entity. Why? Because courts frequently substituted ongoing royalties for injunctive relief. This trajectory is not merely a more flexible version of enforcement, but it reflects a movement toward a liability rule orientation. Monetary compensation becomes an acceptable substitute for exclusion. I'm sorry, I will need probably 10 minutes. Let's go to a specific kind of enforcement. I'm talking about enforcement with respect to SEP. SEPs occupy a distinctive position. Why? Because standardization can magnify the exclusionary potential of patents. Access to entire product categories may depend on implement the standards. Yet, it is important not to mystify the SEP. The underlying economic mechanism can also arise, the mechanism of control over a critical technological input can also arise in non-SEP context, where, for example, we have broad or system-level claims that create real bottlenecks. Standardization thus magnifies the leverage, but it does not create it from nothing. We all know that with regard to SEP, standard organizations commonly require declaration of willingness to license on friend terms, although there are different policy details. There are cases in which opt-outs exist. In the US, early hold-up concerns led some to argue that a friend declaration should preclude injunctions. That categorical view was rejected by the courts. The court specified in the US that friend commitment is not a bar to injunctive relief. Notwithstanding this, as a practical matter, injunctions remain uncommon in SEP disputes because SEP holders frequently struggle to prove irreparable harm. Their business is licensing, and in a certain way, friend commitments suggest monetary compensation is adequate. The EU follows a different architecture, and IPRED secures injunctions as a primary tool. Within the IPRED, there are no SEP-specific enforcement rules. And the guidance we had comes from the Court of Justice, and in particular from the Huawei judgment, within which the court places injunctions as within the competition law framework, and underlined that the entitlement to injunctive relief is conditioned by a negotiation protocol. So this negotiation protocol that is designed to prevent abuse of dominance and preserving the enforceability of rights had been followed also by national courts. And this is what we have now, together with, as we will see in a while, the UPC recent judgments. With respect to propose a regulation on SEPs in 2023. Such proposal was abandoned by the EU Commission in July 2025. For the time being, although there is a case pending before the Court of Justice between the Parliament and the EU Commission, for the time being, the regulatory debate remains open. But yet, judicial practice has continued to develop balancing mechanism through doctrine rather than through a full legislative regulation, a full legislative design of the remedies. I need to go a little bit faster and to go to the central institutional claim. European proportionality has emerged as the key steering device in enforcement, but it has a clearly different character, distinct from the US equitable model. EU proportionality operates primarily to prevent abusive or excessive harmful measure and to calibrate injunctions in exceptional cases. It does not function as a full balancing test comparable to the eBay factors. Remedies remains rooted in statutory entitlement, minimum harmonization, and they are tempered by structured constraints. This is why, according to my paper, an eBay-style legislative revision of IPRED is undesirable. And it would be a mere it would not be a mere technical update, but it would conflict with the directive's minimum harmonization model and undermine the legal certainty and predictability that the EU enforcement acquis is designed to guarantee. There is not only this point. The transplant would be undesirable also with respect to the procedural culture of civil law systems. Why? Because in this procedural culture, legitimacy expectations emphasize systemic coherence, codification, constrained judicial discretion, rather than broad equitable balancing. Moreover, also policy considerations reinforce the same conclusion, a competitiveness agenda oriented towards simplifications and predictability, as Draghi report emphasized, and a competitive agenda that has to attract high-tech investment is better served by incremental rule-based refinement of the enforcement structure than by introducing a discretionary test that could increase litigation complexity and uncertainty, and moreover divergences among the different member states. This is where the Unified Patent Court becomes particularly significant. I would like wholly to mention the UPC Court of Appeal of 25 November 2025 in Merrill versus Edwards Life Science Corporation. Within this judgment, the court reaffirmed that injunctive relief remains the default remedy, but upon a finding of infringement, but it clarified also that the default is not absolute, and it interpreted proportionality as a mandatory legal limit on remedial powers. Even more importantly, within this decision, the court explicitly extended the proportionality analysis beyond the bilateral interests of the parties to encompass third parties' interests, notably in this specific case, patients in the medical device context. Seen in this light, I deem that the transatlantic comparison becomes clearer. Both systems, US and EU, pursue fairness, but through different remedial traditions. The US relies on equitable discretion as a general gatekeeping device. The EU relies on statutory entitlement tempered by target proportionality limits. The emerging Unified Patent Court jurisprudence suggests that supranational Europe is consolidating and not abandoning that model. For all these reasons, the appropriate direction, in my view, is not to import US-style equitable discretion in IPRED, but the more coherent pathway is continued careful judicial refinement and supranational convergence, so that the European enforcement framework remains effective, predictable, and constitutionally grounded, while retaining the flexibility needed to prevent abuse in exceptional cases. Thank you very much.
Thank you, Francesca. I see this is such an important topic, and it's very interesting to see this comparison. During the presentation, proportionality was described as acting primarily to prevent manifest injustice. And I was wondering, how does this characterization relate to the objectives of the proportionality test you mentioned, Francesca, under Article 3 of IPRED? Léon, would you like to start?
Yes, very much. Thank you, Claudia. And of course, thank you for having me a part of this webinar. Proportionality is a topic that's very close to my heart, as you may know. So it was a pleasure to read Francesca's paper, but I have to say on some points I had a little bit of trouble following it. In particular, Francesca ended on this notion that proportionality serves to prevent abuse in exceptional cases. Now, the way that I read the European case law is that proportionality has a fairly defined meaning, and moreover, and I think this is quite important to appreciate, it has horizontal direct effect. The Court of Justice has explicitly confirmed that. Now, what does that mean? That means that it has, by definition, that is a fairly delineated meaning, because otherwise parties couldn't rely on it. And if you read the case law, you find nothing at all about abuse or exceptional situations or some kind of balancing of interests. This is my contention also in my book, there is nothing, I think, to suggest that proportionality is some kind of open-ended balancing test or was intended to be that. What it is, I think, is that it is trying to set a limit on how your remedy relates to the graveness of the violation. And I think that really clearly maps onto a principle of patent law, whereby we always say the monopoly of the patent holder has to be proportionate to their inventive contribution. And so what I think proportionality's primary function is, when read properly in light of the case of the Court of Justice, is to precisely safeguard this principle, to make sure that if your invention is for if your patent is for a particular invention, then your remedy cannot expand the scope of exclusivity far beyond what that invention was and what your contribution was. And I call it that in my book, the principle of commensurate scope. And I think a lot of the problems that we're discussing today would go away if we would clarify this.
Thank you very much. Francesca, what do you have to say to that?
I do not. Yes, I mean, I said clearly that proportionality prevents manifest injustice, but I deem that I do agree with Léon's book, Léon's thesis, as authoritatively explained in his book on the proportionality test. In a certain way, proportionality is a general and mandatory principle, but when I'm saying that it prevents manifest injustice, I'm saying that this is in a certain way, the outer limit of proportionality, not the core function of proportionality under IPRED. Manifest injustice is in a certain way the boundary of proportionality, not its essence. So I do agree with some of the considerations by Léon.
I appreciate that. It seems that you are more aligned than it seemed. How do you assess the role of proportionality in ACP enforcement, and what implications does it have for innovation and enforcement practices? Who would like to?
Léon, are you going?
Absolutely.
Okay.
No, if you allow me, because that was the other thing that stuck out to me. That stood out to me that when you, Francesca, were presenting on the balancing mechanisms that courts have developed in when it comes to SEP jurisprudence, and I think that here proportionality really it's a missed chance for European law, because in some jurisdictions maybe there is such a balance, but there are other jurisdictions in continental Europe where I think in SEP cases there is very little by way of a balance. So I think if you look at the general case law trends, if you are an implementer, then it is virtually impossible to successfully assert a friend defense, right? And so what that means is that we're going towards a situation where injunctions are the norm, And so long as the SEP holder is not manifestly unwilling as a licensor, they will get an injunction, and that basically means that they can charge, the sky is the limit when it comes to the invention. I think that that risks negating what is specific about SEPs, which is this rent obligation. So I completely agree with Francesca that SEPs, they're patents and there should be an entitlement to injunctive relief, but I think we should also be considerate of the fact that there is a rent encumberment there, and a case law that develops to basically, render that meaningless. I think that is not a balancing mechanism. And as far as I'm concerned, proportionality could play a much more important role there, although I think that the primary culprit here is the Huawei framework, and we would definitely benefit from further clarification of that.
Thanks, Leon. In the presentation, Francesca was talking about this protocol that we have seen in Huawei versus CTE, where courts can look at the behavior of the parties. So it's a kind of embodied disproportionality already in this protocol. This is though not a strict step-by-step, is to be interpreted in a flexible way, but it gives both sides possibilities to know how to behave. I'm going to put in the Q&A a link also with the website of IP Council, where we have kind of these steps and also how different courts have interpreted these steps, and so that I think it's important information. So
yeah, it's a great resource.
Yeah. And Francesca, I don't know, Francesca, Kristen, any of you who wanted to say something else?
I would like to add that, in my view, within the SEP enforcement, proportionality plays a disciplinary role, but in a certain way, in a structured and limited sense. It does not undermine injunctions as the default remedy, but by constraining their exercise in cases of abuse or DAP or exceptional harm, and notably in a certain way, for example, if we look to the Huawei's ZTE case, I think that this has been a positive development, because within this framework, strong enforcement incentives are preserved, but it is possible also to prevent manifestly excessive outcomes. Proportionality clearly operates within a rule-based system and does not introduce at all open-ended judicial discretion. In my view, it both supports innovation incentives and legal certainty, and it does not weaken SEP enforcement.
Mm-hmm. Kristen, you've been a bit silent, so I have a question for you, which I know for sure you will be having a lot to say, which is regarding eBay. And the question is, how has the eBay decision play out in practice in the US for patent owners, including SEP owners? And what recent empirical studies tell us about changes in injunction seeking behavior?
Well, thank you, Claudia, and thank you for IP Council for inviting me and allowing me to engage with Francesca's paper. It's been very interesting to see how perhaps people in Europe view the eBay, because I want to start by correcting not Francesca's understanding of the law, but correcting how it actually is playing out in the United States. Because while it's intended as an equitable discretion doctrine, And that's what the eBay opinion says it is. And as Francesca rightly noted during her presentation, right, prior to the eBay decision, injunctions were nearly automatic. They didn't go through any sort of framework. It was just if there's a patent that's infringed, injunctions will issue. And what eBay said, the case itself, the law said, is it's an equitable matter. You have to consider irreparable harm, whether money damages can make you whole, balance of the hardships, and the public's interest. And that sounds like a really reasonable framework and very in line with the United States conceptions of equitable remedies. What's interesting is that's not how it's being applied by the courts. So that's really the problem, right? Is that if that was the law that we saw being applied, I wouldn't spend my entire academic career writing about why eBay shouldn't exist and certainly shouldn't be imported into the European rules. So what we're seeing instead is a flip of that. And so a number of empirical studies have been done. As Francesca's presentation noted, NPEs or patent trolls, or I like to call them patent licensing entities, firms for which licensing is one of their primary modes of income, because of the step in the equitable test that says, would money damages make you whole? They oftentimes do not receive injunctions. Similarly, SEPs, right? Because of the FRAND obligation, as per the discussion earlier, because of the FRAND obligation, again, the way the United States courts have looked at that, they said, fine, money damages would make you whole. You have a FRAND obligation. And so SEP owners and non-practicing entities are most often not receiving. They are unlikely to receive injunctive relief in any case. And we don't have the Huawei ZTE framework, so we don't have a discussion of the licensing behavior, the negotiation behavior leading up to it. It's just simply, if you are an SEP owner, that's too bad. Injunctive relief is not for you. So what I feel like we've seen in the United States, given that it's been a full tip for certain patent owners of certain types, no injunction for you. I think what you end up there is you end up with predictable rights, but they're not good for the patent owner. They predictably, your patent will not be able to be enforced. And so that's kind of a negative. Of course, you receive damages. The damages get set by the courts. There's empirical studies about whether or not those damages set by the courts are notoriously lower than what would have happened if the parties had negotiated in good faith. Again, we don't have the Huawei negotiation analysis. So, but there's been some interesting things also happening in the United States that I don't want to take all the time to tell you about the United States, but I do want to take all the time to tell you about the United States. But a friend of mine, her name is Christina Acri, she has done a very interesting study. She's an economist, so she does numbers. I look out there and see what's happening, but she actually goes out and digs up the numbers. And one of the most interesting things that we have seen in the United States after eBay is even companies who might otherwise receive injunctive relief are choosing not to pursue it because they don't want to get into this system. So in that respect, it even feels like at its best, with eBay at its best as a full equitable discretionary remedy, if parties are looking out at the eBay landscape and saying, it's not even worth our time to ask for an injunction. And if a patent at the end of the day only ever is, an exclusive right, which is how we have it written into our patent system in the United States, if that's true, then parties are just giving up what is one of their rights simply because eBay has turned it into a situation where you're probably not going to win. At least that's the way that parties are, or it's not worth the hassle. It's not worth the hassle. So it was a really interesting study when my friend Christina wrote this paper, because it's like, wait a second, that doesn't even make sense. It doesn't make sense. Why would companies who might otherwise get injunctive relief just choose not to pursue it because eBay has created a hassle. So the one other thing, and I will say, and then I will stop because I really certainly don't want to just spend my whole time telling you all about the United States. The one thing we have also seen in the United States, when we have eBay and we have certain patent owners who are unlikely to receive injunctive relief, is we have seen, and another friend of mine, Jonathan Barnett, has done some studies on this, situations where infringers make what seems to be an economically rational decision to infringe and then pay. We call it efficient infringement. I literally hate that term. I call it predatory infringement. Nobody has yet adopted my branding of it, but that's okay. I'm going to continue with that. But if you know that at the end of the day, the worst thing that will happen is you will go to court and the court will not issue an injunction, but will issue a royalty rate that may be lower than you would have gotten ex ante, then why in the world would you not infringe first? And although we have those exemplary punitive damages that Francesca noted on her slides, they're rarely granted. And we don't have, again, we don't have the Wale framework where we can look and say, hey, wait, you didn't engage in that negotiation in good faith. And so this infringement, the eBay standard and the way that it has played out in the United States has really given rise to an opportunity for opportunistic infringers to say, well, you know, they're not going to get an injunction, so let's just ride this out and see what happens. So with that, I'll pass it back to the folks who know so much more about Europe than I do.
Thank you, Kristen. Any thoughts? Yes, Francesca, go ahead. Oh, please unmute before. Yeah.
Sorry. First of all, I would like to thank Kristen because I was saying before a friend declaration has not been conceived as a legal bar to injunctive relief, but actually it was not conceived, but probably it has been applied in this way. Actually, what you said is very, to be honest, I went through some of the empirical studies you were mentioning. I didn't probably get to, for example, to the fact you were mentioning about the attitude of asset holders not to ask for injunctions because they know that it's not for them, okay? And this clearly, in a certain way, better explains also the statistics about the denial of injunctions. With respect to opportunistic infringement, I am quite glad that this is one of the most relevant problems you are emphasizing, because actually this is one of the point on the basis of which not only with respect to SEPs, but generally speaking with respect to the possibility to include in European framework the eBay test, actually it's one of the biggest risks I see in doing it. Infringers that make rational choice to infringe because it is more convenient than not to infringe, and this clearly is something that is by principle against enforcement and against proportionality, and I mean against enforcement as it is at least conceived in the EU system. So thank you.
Léon, I don't know if you had something else to add, or shall we go to the next one?
Yeah, please, because if nothing else, I just want to note that it's nice because if there's one thing we all agree on in this panel is that we should not adopt the eBay approach in Europe, because yeah, even though I am in that sense a supporter of a stronger proportionality test, I mean the eBay framework, how it has developed, is really, I think, a cautionary tale for everybody who believes that equitable balancing of any kind is a good idea. I will say, however, that, you know, also in the United States, I think it's quite clear that the sky did not fall down, right? So the empirical studies that I have seen is you still get you have a 75% chance of an injunction. So it's not like this is entirely off the table. And the other thing that I think is interesting, if you read this case law, and I've spent a fair bit of time with this, is that you see a very high degree of fact sensitivity to these disputes, right? So what it forces courts to do, and again, I think they do it in a manner that's completely incompatible with how we view patents in Europe, but what it forces courts to do, this eBay decision, is to really look at what are the specifics of this case, and is it really, appropriate for this patent holder to just, enjoin this defender in this particular case. And I think one of the sources of inspiration that I think we can find in the eBay case law is how they developed what you could call the US equivalent of a commensurate scope-based approach, and that's the causal nexus test. So there is a fairly sophisticated test which tests in situations where you have a component patent and you want to take off the market an entire device that happens to incorporate this component. You have to show that there is actually market demand for that particular, or that the infringing product is sold because people want that infringing component. Again, I think that particular test is incompatible with how we view patents in Europe. But what I think it shows is that there's, people that I deeply respect, sensible minds, have thought about it and have said, well, maybe injunctions are not should not be an automatic remedy in every case. And I think that is a lesson that perhaps we can take away from the eBay framework without adopting it wholesale here in Europe.
I think comes to the point of whether the decision was intended to be interpreted as it has been, or not at all, as Kristen have pointed. I personally remember having read the decision the first time and thinking, this is a good decision. And then suddenly being later on the implementation and really not understanding what was happening up there. And I see I was not the only one. I was thinking, because I've been seeing different events where they were talking about bringing eBay to Europe. I've never seen any webinar in the US about bringing Huawei versus CT to the US. Like, we have a great system and we keep bringing it to elements. In any case, maybe quickly to the next question, because Francesca, in your paper, you raised the question of whether IPRED should be strengthened. And so I wanted to ask to the rest, do you agree with that? And if so, what concrete changes, if any, would be desirable or realistic? And I'm going to ask you to be super quick, because we also have one question, another question from the audience that I definitely would like us to answer.
To better specify what I was mentioning, because I don't want to be misunderstood, I think that any kind of revision of IPRED should be targeted and clarificatory, and overall, I deem the incremental judicial development is preferable to any structural legislative revision. So just to be honest and to make it clear. Thank you.
Thanks for the clarification.
Yeah, I would agree with that, actually, because it goes also to your point, Claudia, about the interpretation of this eBay decision. Yes, I don't think it went in a positive direction. On the other hand, it's quite difficult, right? So I think the number one thing on my wish list for proportionality is that we finally clarify what is it that we're trying to achieve with it, because it is still a completely open question. And I think, frankly, that's a question for the courts more than the legislator. And I think once we have that clear, the incremental change that Francesca is advocating for will be much easier to achieve, and we'll be on a clear track of where we're headed.
Thank you. Well, maybe it's a material for another book. So to inspire the courts. In any case, I have here one question from the audience. It seems to be for you, Francesca. It says, if I got it right, you do not see a need for revision of IPRED, at least with regard to injunctions and proportionality. And that person asked whether that's the correct understanding, and suggesting that maybe it would make sense to look at a minimum harmonization, for instance, with regard to dynamic blocking injunctions. So just wanted to check whether they have any immediate answer to that.
I mean, if I have correctly understood your question, yes, it's true. I was just talking about judicial development or refinement.
Okay. So the question was also asking whether a minimum harmonization should be desired, and a proposal was with dynamic blocking injunctions.
Yeah, a minimum harmonization is okay, and with respect to dynamic injunctions, we are talking about, I mean, intermediary and so on. For the time being, there is there is a recommendation on blocking injunctions, and for the time being, I do not think that it should be regarded as something that should be I mean, IPRED is more structural, okay? So blocking injunctions have specific rules, but in a certain way, I do not think that it makes too much sense to put those rules in the IPRED, so to revise the IPRED in order to include them, but it's much better to disciplines and rule about blocking injunctions in specific legislation or within recommendations of law, I mean.
Thank you. Since we are approaching to the end, I'm going to ask you, each of you, to spend 1 minute with one final thought, something that we want to maybe bring to the group for us to consider, one final message to the audience. Kristen, would you like to start?
Sure, thank you. Don't bring eBay to the European Union. Would be my bottom line elevator pitch. But I think it's important to recognize that while there may superficially be some good things about eBay, the way that it has played out is really what's much more concerning. And looking at that rather than just looking at the case law, I think would be my suggestion for anybody who thinks that this is an interesting idea to pursue. So thank you.
Thank you. Léon?
Fully agree. I don't think we need an eBay type revolution here in Europe, but at the same time, I do think, you know, to quote the old Bob Dylan song, the times they are changing. Innovation by its very nature, it isn't constant. And I do think that as the type of innovation that we see, as the geopolitical dynamics of this change, we do need to be mindful of these changes. And I think that in appropriate cases, the patent laws that we have and the patent system that we have should grow with it. And I think IPRED gives us the tools if we answer the fundamental questions.
Thank you very much. And Francesca?
So I think that EU IP enforcement is the product of a procedural tradition that is rule-based, predictable, and calibrated through proportionality. Legal remedies are embedded in institutional cultures, so I deem also that risky transplants, such as the one that we could do with respect to the eBay test, could undermine coherence rather than improve it. So I'm saying it not because it's clear enough that there are all the economical, geopolitical, and other kind of considerations we made before, okay? From a procedural law point of view, I deem that, as Miriam Damaska explained in many essays, common law systems evolved around principles that are distinct from our systems, from the ones of our systems. And in my view, the EU IP rights enforcement does not call for reform, but as I said before, at least it calls for careful judicial refinement within its own constitutional logic.
Thank you very much. And with that, we come to the end of today's webinar. Thank you very much, Francesca, Kristen, and Léon, for sharing your knowledge and expertise. Thank you also to all of you for attending this webinar. A recording of this presentation will be made available on 4AP Council's website tomorrow. Don't forget that you can anytime follow us on X, LinkedIn, YouTube, and Instagram. Our handle is @4AP Council. There you can find out about IP news, resources, interviews, and future webinars. And finally, I would like to remind you that tomorrow you will receive an email inviting you to complete a 1-minute survey about this webinar, and we will love to have your feedback. Thanks again, and goodbye to all of you.